Welcome to Our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to Our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Christina Ma, and today's episode is 1, 2, 3 Strikes You're Out, part 1 of a 2-part discussion with defense lawyers in the 3-part chicken price-fixing trials. In July 2022, a jury acquitted 5 defendants charged by the U.S. Department of Justice of conspiring to fix the price of chicken. The trial and acquittal were notable in that it was the Justice Department's 3rd attempt at a conviction. In this episode of Our Curious Amalgam, we'll speak with 2 of the defense lawyers who argue the case for an inside scoop of the chicken saga. And join us next week in part 2 of this series when our guests will return for further insights on trial strategy and how the case was won. Joining me today is my co-host, Jaclyn Phillips. Hey, Jaclyn.
Hey, Christina.
So who are our guests today?
Well, like you said, we have 2 guests joining us today, both from the Denver-based firm Recht Kornfeld. Rick Kornfeld is a former federal prosecutor and seasoned trial lawyer. Rick specializes in white-collar criminal defense, corporate compliance, and internal investigations. We also have David Beller. David began his career as a Colorado State public defender, and today he continues to specialize in criminal defense and represents individuals and organizations who are involved in state and federal criminal investigations, grand jury proceedings, and more. Rick, David, and their colleague Kelly Page led the litigation team that secured a full acquittal for their client, who was a poultry industry executive, after, like you said, 3 criminal trials brought by DOJ Antitrust Division. So welcome, both of you.
Thank you for having us.
Happy to be here.
So I'm going to throw it to Rick for this first question. And can you just set the stage for us and give our listeners a brief summary of DOJ's allegations and the facts or theories in support of these allegations?
Sure. So the Antitrust Division, as your listeners probably know, have been focusing on a number of industries, including various protein industries. And they started looking into the chicken industry a number of years before David and I got involved in this case. We actually got involved in this case after our client was indicted. But the government has based in Denver, or brought in Denver, 3 separate indictments. The first was against 10 individual defendants, including our client. Our client was the president of a small one-factory chicken producer called Claxton Poultry in southeastern Georgia, privately held. 2 of the other defendants were former CEOs of Pilgrim's Pride, which is based in Greeley, Colorado. And then a number of the other defendants were high-ranking or mid-level sales folks. So indictment number 1, our case involved 10 defendants, and it was a single count of violation of Sherman Act and conspiracy to bid rig and fix prices. A second indictment is pending also in the District of Colorado, originally against 4 Pilgrim's Pride employees. The government in July dismissed against 2 of them. So that case will be going at the end of October. Similar allegations, similar underlying facts. And then there is a third pending indictment against Cook Foods, which is based in Illinois, and Claxton, our company. And that case currently is set for trial in April of 2023. And again, same allegations. And the basic theory behind it was in this closely consolidated industry, the producers talk to each other all the time because they're in the supply chain of places like Chick-fil-A or Popeyes or KFC. They talk to each other about issues pertinent to their industry like avian health, labor issues, etc. And the government's theory was essentially that the number and the ongoing communications were indicative of a price-fixing conspiracy. And if, in fact, you looked at the prices for all the producers went up around the same time, and there was a significant price increase in 2013, 2014. So it was a circumstantial case really based upon the number of communications and a very macro analysis of the prices.
Very helpful background for a saga that seems to not even yet be over, even though we're here talking about 3 trials that happened. So, I think our listeners may know from all the news surrounding it, but just to make sure we're all on the same page, what were the outcomes of the 3 trials that your client was involved in?
So the outcome in trial 1, the jury hung as to all 10 defendants. So they did not come to a verdict as to any of the 10 defendants. That was right before Christmas of last year. The government then decided to retry the case. It had to be brought within 70 days under the Federal Speedy Trial Act because none of the defendants waived their speedy trial. So the Tuesday after the President's Day holiday, we went to trial again. The first trial was about 10 weeks. The second trial was about 6 weeks. Same trial teams, same result. The jury hung as to all 10, meaning they couldn't reach a verdict. In some of the information we later learned, we think that the jury split got worse for the government, the second trial as compared to the first. Then the third trial, the government decided to bring the case again. As some of the listeners may know, Chief Judge Brimmer summoned the Deputy Attorney General in charge of the Antitrust Division to come to Denver and explain why the government thought that they would achieve a different result. And the Deputy Attorney General, Jonathan Cantor, explained to the judge that the government had confidence in its case and would simplify things and would consolidate things. They subsequently dismissed the case against 5 of the salespeople. And then we went to trial again in early June, this time against the 5. The Deputy Attorney General Cantor's confidence was a bit misplaced because this time the jury did reach a verdict, and it was not guilty as to each of the 5 remaining defendants. So we got that verdict in less jury deliberation time than the first 2 trials, and we got that verdict in mid-July.
Wow. So before we, dig into the nitty-gritty of all 3 trials, how much time was it from, indictment of your client through the jury verdict in this final trial?
It was about a year and a half, almost 2 years. So there were superseding indictments, and we had an original August trial date, and not surprisingly, things were delayed a little bit. We had some COVID-related issues, but to your point, it was a long saga. And the other thing that it should be noted, while David and I are based in Denver, the other 9 legal teams were not based in Denver. The prosecutors were not based in Denver, and the defendants were not based in the state of Colorado. So David and I got to, and our partner Kelly Page, we all got to sleep in our own beds and see our families and pet our dogs and do all those things. But everybody else really relocated to Denver 3 different times. And of course, it wasn't just for the trials. It was for motions hearings. It was for trial prep. So the wear and tear on the clients in particular, but also the lawyers, was significant. In the case of our client, Michael Freeze, he remains the president of Claxton Poultry. So while we were in the middle of this trial, Michael was still running a multi-million-dollar business, and his colleague Scott Brady, who was a high-ranking salesperson at Claxton, he was still having to do his job every single day that they were in Denver engaged in this trial. So it was a significant undertaking. And while Judge Brimmer raised that issue with the government when Jonathan Cantor was in Denver, I don't think that was a factor that was of particular import to the Department of Justice. It certainly was of import to all of us.
Yeah, understandably. And, this might go without saying, but what was the, I guess, reaction among, the defendants and defense counsel upon hearing that Antitrust Division was going to move forward with that third trial?
It was overwhelming to them and unbelievable and shocking. And it's not just it wasn't simply that they're moving forward in a place of principle. It's the fact that there are real lives that are being impacted and employees and families. And, this is really a situation in which we believed in our clients' innocence from the beginning. We believed in their not just factual innocence, but legal innocence. And so I think it was both discouraging and heartbreaking that they were moving forward and, frankly, shocking amongst the lawyers.
When we were preparing for this episode, Rick and David, you had sort of mentioned, trials 1 and 2 as being sort of distinct and separate in your mind from trial 3, in part because, all of this is happening. And in your head, you're like, we need to get this acquittal for our client so they don't have this ongoing uncertainty. They don't have this emotional, turmoil that they're going through for the period of time. They're not dislocated from their families and homes again. Tell us a little bit about, diving into each trial, sort of why you separate trials 1 and 2 in your head from trial 3, aside from the obvious verdict, and how, the approach and, I guess, theories or defenses changed across the trials 1 and 2 and 3.
So, when you put, I don't know, somewhere between 40 and 60 defense lawyers in a room, and tell them to try a case together, you're going to end up with, as this may surprise people, different opinions. And so in the beginning, we really tried to center on a central theory to make sure that the jury was not going to be confused by different arguments and different theories. And that's not to say that there wasn't legitimacy to every single one of them. But when you have 16 million documents and 10 different defendants, there's going to be different strategies that are being taken and emphasis placed on different pieces of evidence. And so trial 1, I think the different defendants were much more focused on their individual stories and their individual theories of innocence. By trial 3, there was really, I think, enough trust amongst the different lawyers, as well as a lot more cohesion in terms of what the messaging really needed to be for the jury to be able to understand. And so it really was an evolution of a defense theory that just created, or what evolved was a narrative that was far easier for, I think, the jury to really understand by the time you get to trial 3.
And I agree with all that. The other thing that really evolved was, the worst facts. The government really tried the first case as essentially these guys were talking all the time, and therefore they were colluding. We ended up with a jury instruction, although we didn't know we were going to get it at the beginning of trial 1, but we ended at trial 1 with the jury instruction that said that's not illegal. In the absence of an illegal agreement, that it's not illegal to talk. And so over time, I think we affirmatively, you always have to deal with and embrace your bad facts. But I think at the beginning, we were sort of trying to explain why these guys talked all the time. And by the third trial, that was a factor. But we took a more affirmative position, which is, yeah, they talked because of these reasons. And frankly, they talked because they could. And this case isn't about talking. The other thing that evolved, and I think this was significant between trial 1 and trial 3, was in trial 1, the government put on a lot of witnesses, many of whom had nothing, frankly, substantive to say, a lot of document custodians. We put on a very minimal case. Trial 2, the government consolidated its case. The defense beefed up its case. Trial 3, the government really consolidated its case even more, and we beefed up our case even more, putting on a bunch of the customers, people that are buyers for Popeyes and Chick-fil-A and KFC. And so part of the narrative that developed is the government is unwilling to tell you, the jury, the whole story. They're cherry picking the facts. They're ignoring witnesses who are their erstwhile victims. We, the defense, aren't afraid of the whole story. And even though we have no burden, we're going to present to you the whole story, not the things that, the government kind of wants to keep from you. And I think that dynamic, not just the fact of what we presented, but this dynamic of the government interviewed these people, the government could have subpoenaed these people, but they didn't. We're the ones who brought them in. Really, I think turned, the sort of atmospherics of the case, and obviously we think in our favor.
So looking back at how that evolution occurred, this is sort of a question of maybe, what could the defense or what could the division have done better during their first 2 trials, but also a question of, do you think it would have been possible to sort of have the approach that you had in trial 3 and trial 1 without, having seen how the government's case evolved and having the experience that you had earlier?
Well, I think it's an interesting question, and I think practically speaking, the answer is probably not. I think the answer is probably not because the case was so incredibly massive in size and massive in documents that I think the government going into trial 1 are the ones who actually knew what the case was going to look like. And certainly, while there was a speaking indictment, it was such a massive indictment that the defense really didn't have a good insight into which pieces of evidence or which documents the government was going to be introducing. And so by trial 3, certainly there was a lot more understanding of both what the government planned on putting forward, number 1, and number 2, we as the defense, of course, have the benefit of our clients who are telling us and teaching us all of the different circumstances. The government didn't. And so by trial 3, we really had a good understanding of why the government believed that there was illegal conduct and really what the government did not know. Or did not understand. And we were able to really take advantage of that and have the jury understand the factual scenario that the government simply didn't.
So there is, you can win, right, a conspiracy to fix prices based on tacit collusion, based on circumstantial evidence, right? So, I guess tell our listeners what the standard is and where you think sort of the circumstantial evidence and the facts just didn't sort of merit or meet that standard.
The standard, of course, is, you have to prove the existence of an illegal agreement. And if you prove that, then and only then do you go to whether or not each individual knowingly participated in that illegal agreement. And circumstantial evidence is absolutely, part and parcel of most, if not all, white-collar cases. Rare is the white-collar case where someone sends an email saying, okay, are you down for the conspiracy? What happened here, though, it was interesting. The government sort of, from a theory standpoint, wanted to have it both ways. On the one hand, they argued that there weren't explicit communications because these defendants wouldn't be so foolish as to engage in explicit communications. And then on the other hand, out of 16 million documents, they cherry-picked kind of a greatest hits list of 10 or 15 texts, emails, which taken out of context could be very problematic. What the government failed to do, and what they knew we were going to do, because we did it all 3 times, and our presentation got a lot more refined, was not only to own the bad communications, which of course you have to do, but to put those into context and then to further argue that the government could have done the very same thing, but they knowingly ignored the context of these communications because that undermined their theory. So it was a bit of, jump to conclusions sort of argument. And I think that was very effective. And then the other thing the government tried to do was to breathe some life into those communications by putting on the stand so-called insider witnesses. In trial number 1, they put a guy named Robbie Bryant on who works for Pilgrims, had nothing to do with our clients and many of the other defendants. In trial 2, they put Mr. Bryant on along with a guy named Carl Pepper. And in trial 3, they retreated from Mr. Pepper and went back to Mr. Bryant. Now, it came out in trial that they had prepped Bryant more than 30 times. And at the end of the day, and he had admitted lying to the government about unrelated matters, but lying to the FBI. And at the end of the day, he really wasn't an insider. So their attempt to sort of breathe life into some of these communications as to the Pilgrims defendants, let alone the defendants from other companies that he had no contact with, was really unsuccessful and, might have been perceived as a bit of a Hail Mary by the government. And we certainly argued that, his foibles are his foibles, but more than anything else, he really doesn't speak to the allegations. So their plan of, a classic insider or a classic flipper from a substantive standpoint really just didn't come to fruition.
And an important point to your question regarding the standard, and that is, independently derived pricing, it's axiomatic to say that is not pursuant to an agreement, not if it was independently derived. And the inside witness that Rick is speaking about testified to the jury unequivocally that at all times he considered other chicken producers' prices for the purpose of independently determining his price or independently setting a price. Such an important detail and completely guts the element of a Sherman Act violation. And for reasons that I think in the end, none of us quite understand, that was an important point that the government really never jumped on, but clearly the jury considered.
And another factor kind of related to that, at the end of the day, our company is a small company that doesn't move the market, doesn't have the leverage to move the market. And we put on evidence that when the buyers gave us feedback that said our price was too high, we lowered our prices every single time. We literally could not afford to ignore our customers. So, you don't have to be, we put on an expert witness in trials 2 and 3 who's former antitrust economist and is the dean of the Yale Business School. But you don't have to be the dean of the Yale Business School to understand that if the allegations are a conspiracy to maintain or raise the price of broiler chicken, and in fact, the evidence empirically establishes that we lowered our prices, that is completely inconsistent with the government's theory. And, I think that was a very macro fact and a very simple fact, but it's a very simple fact to understand. And we obviously, put a lot of evidence on to indicate how we come about, how we price our chicken, what factors we consider, and how we reacted to our customers. And we put the customers on to tell the jury the same thing.
And it sounds like from what you're saying, we're seeing your evolution, your defense theories. You put on an expert witness, you put on customers, as you tried to tell more of your story. Did you see an attempt from the division to kind of match that change in theory to, disprove any of that or overcome it at all?
It's interesting. And I think in all three cases, certainly in trial number 1, the division was very much in the defense and seemed to be chasing the defense through most of the trial. The government had a theory. The government simply believed that communication about pricing was illegal. And as Rick said, they were picking and choosing text messages and pointing to them out of context, saying, well, clearly these are competitors discussing pricing. Ergo, it is illegal. And we're chasing the defense. And really, there was a theory, as Rick said, that evolved throughout each one of the three trials. And that is the defense was really the narrative of the story. The defense was really teaching both the industry as well as pricing, all the way down to supply chain, really basic economic issues to the jury. And the government was chasing us throughout that. And so I don't believe that the government ever really got to the point of trying to get in front of the narrative. The government's narrative was simply, look, they're discussing pricing. That's a problem. Therefore, you should convict them. And I don't think had the knowledge and certainly did not have the witnesses to be able to teach it to the jury in a way that was easy and understandable for that jury to be able to go along with the government's theory.
So I think that's a great teaser for next week's episode, when we're going to dive more into some of the strategy behind the scenes of what was happening. But before we let you go this week, we did want to ask you both a couple of questions we ask all our guests. So I guess I'll start with, Rick, to tell us something about yourself that we wouldn't know about you if we only knew you professionally.
Well, during this trial, in addition to focusing on that, I have been focusing on training for the Leadville 100 mountain bike race, which is in August. And when I signed up for it last fall, it was a really great idea because I figured I would have more time than I ended up with this spring and this summer to train for it. But hopefully, chicken notwithstanding, I'll be ready to race my bicycle at 11,000 feet above sea level.
Wow. Only in Colorado. Lawyer by day, mountain biker by night. And what about you, David?
I got my first experience, what would become as a trial lawyer, by doing live animal shows at the Philadelphia Zoo. And if you can be comfortable with the unpredictability, holding an animal, doing a live animal show in front of a gigantic group of people. Certainly anything a witness was to throw at you was something that is certainly easy to deal with by comparison.
Okay, so follow-up question. Scariest animal that you had to hold?
Oh boy, probably. So my favorite, to the extent this makes me sound like a psychopath, I'm sorry, were probably reptile shows. And so I was able to pull out gigantic snakes and wrap them around my body and then speak to the audience that way. And I'm not a snake person by any means, but that was probably the scariest and most enjoyable animal that I dealt with.
Yeah, I'm squirming. I don't like the way that snakes move. There's something about it, right? That's just a little creepy. So that's great.
It prepares you to be a great trial lawyer, though. That's for sure.
I don't know what that says about your other lawyers or judges, but
some of the witnesses you've cross-examined over the years.
Right.
Well, Rick and David, thank you again for your time today. Again, we're looking forward to having you on next week again. And to all our listeners, thank you for listening to this episode of Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.